Hi, everybody. Welcome to Mormonish. I'm Rebecca.
And I'm Landon.
And we have another familiar face with us again today. Yet again, we have Kolby Reddish. How are you today, Kolby?
I'm great. Rebecca and Landon, how are you?
Oh, we are
I'm
great.
good.
And thank you so much. Kolby is just like he's on the spot. Like this is something that just happened. This is breaking news. And we're like, who are we going to get? Kolby. And here he is, so willing to lend his expertise. So we really appreciate you.
Yeah, of course.
Yeah.
When you told me there was an administrative law decision, I just came running.
He did. He was chomping at the bit. That's exactly right. So let's pull up our slides right now because you've probably seen some posts I've made about this. I'm sure by the time this airs, it probably will have hit some other news sources. But as of this morning, it had not. We were the first ones to break it. We're going to be discussing the Cody, Wyoming Temple, 10,000 square feet, 101 foot high spire. This is the first temple building situation that Landon and I ever became involved in. This is why we're actually involved in other temple building, isn't it, Landon? Cody reached out and said, hey, you know, a Mormonish viewer, and Cody said, there's something happening here. Would you be willing to lend some help to some folks here who are trying to understand what's happening with this temple being built? And the rest is kind of history. And this has been going on for how long, Landon? Almost 2 years, like a year and a half at least, right?
Yeah, I'd say we've been involved about 18 months probably at this point.
Yeah, and we even visited Cody. We have some pictures and some other slide presentations where we visited, met the residents, stood on the lot where the temple is going to be built. There was a final hearing a couple months ago, and just on the 26th, the final ruling came in. We'd all kind of been waiting. It had taken a while, and maybe Kolby can speak to that. We were like, what is happening? But this picture here on the left is the drawing for the Cody Temple. And here on the right is sort of a schematic. Some engineer created this and plopped it right there in the field where it's going to be. Landon and I have stood right there by that fence. Doesn't that look familiar?
It does, yep.
It does. So if you go to the next slide, this is the information that we got from our residents in Cody on the 26th in the evening. And then on the 27th in the morning, they posted this update. Landon, would you like to read what the residents from Preserve Our Cody Neighborhoods posted today?
Yeah, it says on August 26, 2024, Preserve Our Cody Neighborhoods and its attorneys received the district court's ruling in favor of the LDS Church on the various petitions for review. POCN is in the process of carefully reviewing the court's decision to determine our next steps in this process. While POCN fully respects the court's authority, POCN is concerned that the court's analysis is not correct and may merit further review by the Wyoming Supreme Court. POCN will consider filing a timely appeal.
And so this is an option then, Kolby, is that right? They could file some kind of appeal.
Yeah, correct. So the way that appeals work, and I'm actually really excited to talk about this because appeals is actually the area of law that I practice in the most, and it's the one that I'm most excited about. So any final decision, any decision that disposes of a case that like is either a dispositive motion or that is a final judgment is appealable. And we'll talk a little bit more in depth about what an appeal actually is. But at a high level, an appeal is not just a second look at a set of facts. It's not just another trial. An appeal, so when you go either to the Wyoming Supreme Court, or I've argued in front of the Idaho Supreme Court and Court of Appeals, when you're arguing in front of an appellate court like that, your arguments are much less about what the facts of the case are because they've typically been found by either a district court or, like in this case, an administrative agency, which is the planning and zoning, and then is Cody a town or a city? I don't know off the top of my head.
It's a city.
City. Yeah. So the city council. And so an appeal is really about an allegation that someone in the process has committed legal error that requires, basically parts of the case or the entire case, frankly, to start again. And so appeals at a high level are about arguing about what the law is or what the law should be, as opposed to when you're in like a district court proceeding or a trial court proceeding, you're usually arguing about what the facts are. And then an appeal is much more about taking those established facts that have either been established by a trial court or by an administrative agency and applying them to the law.
Yeah, and that makes sense because this suit was all about irregularities, procedural irregularities that the residents felt happened in the various meetings as they tried to get the temple building, pushed forward. So that's what they were. I think that's saying it very simplistically, but The reason that Cody is so unique in this whole microcosm of temple building is because what we like to say is the playbook. It kind of revealed the playbook, what the church does behind the scenes when a temple is coming to your town. And there are variations, of course. And we've seen this with all the cities. In some cases, the entire city council is LDS, like in Heber. In other cases, they have sort of an inside person who might be doing some things behind the scenes. That's kind of the scenario allegedly here kind of in Cody. You have other scenarios in Fairview is different because, no influence there on that town council. And you saw a vote where they said no to the temple at this point without some modifications. Then you have a situation in Lone Mountain in Nevada where perhaps there was some influence with contributions made to the city council via the church's law firm. It's slightly different in every town, but what we do see and what we learn from the playbook is that the things start well in advance, way before any resident would even know there was anything happening in their town. Do you think I'm describing that correctly, Landon, about the playbook?
And I think that's exactly what happened here. And if there's anything to be learned from this, it's the fact that residents are extremely behind the eight ball by the time this happens, because as we go to the ruling, we'll see that basically from the time that the temple design was brought out in a public meeting till the time that it was passed, that the trial judge or that the judge said it passed, was 10 days.
Yeah,
so
it's very fast.
The citizens have zero time to get anything together. Meanwhile, the church has been working behind the scenes for a year and a half, and the citizens had 10 days to respond. This lasted 18 months. The citizens didn't know they only had 10 days. They thought this process was going on, but the judge ruled that it was decided 10 days after they saw the plans. So how do you, in a town, when this happens, how is a citizens group supposed to prepare, and how are they supposed to react when they are given no time to even organize or think? And that's exactly that's exactly what the church wants. We've seen them showing up at towns and presenting the plan without even saying who it is that's making the plan or what's going on in the building.
Yeah, that's the newest thing, not admitting who they are.
So residents have to, the second that something's announced, they have to start looking. But that's even confusing because if you're in Fairview, it was announced as the Prosper Temple, which is 20 miles away. And then they called it the McKinney Temple and they put it in Fairview. So you don't even know what town it's going into. So how do you prepare yourself for something like this?
Exactly. And I think that's kind of by design. And I think we have podcasted about Cody a lot. If you want to go to our Mormonish Podcast YouTube channel or audio, there are playlists, temple playlists, and you will see a lot of Cody podcasts. So we can't possibly talk about every nuance of everything that happens, but we can give you a little idea as we lead up to then what Kolby is going to take us through in reading the ruling. So if we go to the next slide, and this is kind of a timeline.
Can I comment on that? Can I comment on just a few of the things you've said right there? It's actually, so people probably know my background is I've worked in various capacities in as an attorney for the government. And it's actually what you've just talked about, the lack of notice. I'm not saying that the church doesn't take advantage of that, but it's actually a problem that goes deeper than just the issues with the church. This is just something that the church is likely taking advantage of, but it's actually something that I've noticed during my time in practice that's very frustrating to me. The lack of notice that's given to people, whether it's like in legislative hearings or in municipal hearings like this type. The reality is that while most states do have like an Open Meetings Act that will require some type of notice to go out to citizens that are affected, it can be really, really short notice. So like here in Idaho, I know that when I worked more in our Capitol building and I would see the legislative process turning, one of the things that I was often confused by is like you could have these giant legislative changes that would change the way the law works for the entire state. And it really can affect a lot of people and affect a lot of people's rights. But those decisions are made with very little notice to people. A lot of time, like the notice is usually given as far in advance as they finalize agendas and stuff like that. But a lot of times it can result in like less than 24 hours of notice, believe it or not. And that that seems really weird to us and really unfair. But I did just want to highlight that it's not just an issue that affects the LDS Church or the way that they interact with these municipalities when they're seeking temple approval. It's actually something that really, I think, just may be worth people pursuing legislative changes on, as far as the notice that's required to citizens before either a city or a state, frankly, can make these types of changes. So I just wanted to add that little bit of dimension there.
No, that's great. And it is a cautionary tale. And we'll talk about at the end of our little section here how Cody did take steps, the city, after this happened, to shore up sort of their town procedures. And that does involve the length of time of notification. So again, cautionary tale that any town or city can look at. So we just have a very brief timeline of everything leading up to this ruling. And so I'll read this first one. Let's go back to July in 2017. Matthew Moss, a gentleman, is called as an LDS bishop in the Cody 3rd Ward. Okay. 3 years later, in April of 2021, Blocks, that's a company in partnership with Haskell Engineering, had the design and the rendering of the Helena Temple and put in the order for the building modules for is it Helena? It's Helena, right?
Helena, yeah.
It is. Casper and Cody. Okay, this is 2021. Cody citizens have no idea anything's happening, but the order's already put in.
I don't think the temple wasn't even announced till 3 October 2021.
No,
so
we're going to go through the timeline. Yeah, that's
they've
what
already
I'm saying.
ordered the pieces before they've even announced it in conference.
Yep, that's exactly right. So October 3rd, 6 months later, 2021, after the pieces are already ordered, the temple's being created, the Cody Temple is announced at LDS General Conference. But of course, LDS residents who are not people who are not LDS, how would they ever know anything about that? They wouldn't, I don't think. However, who would know something about that? LDS members in Cody would know that there's a temple coming there or near there. So, and there is a city planner in Cody who's LDS. So you always say, Landon, that it seems like if you were an LDS city planner and a temple was announced at conference to your town, you might try to make some phone calls.
You'd make phone calls right away. Where's it going? Yeah.
Yeah,
absolutely.
You might try to. So that's kind of interesting. January 10th, a few months after the temple is announced, 2022, Bishop Matthew Moss is reappointed to the Planning and Zoning Board. So there was a vacancy and Bishop Moss is put onto the Planning and Zoning Board in January. The end of that month.
With a lot of input from the city planner, from what we understand. Yeah.
Yes. The end of that month, January 30th, Bishop Matt Moss is released as the bishop. He's still on the planning board. He's no longer the bishop. And R. Todd Stowell, that is the Cody City planner, is then called as the second counselor into the ward that Bishop Matt Moss had been bishop of. So you can kind of infer that they knew each other. There was a connection. They were in the same ward. They were, incoming, outcoming members of the bishopric. So, but yeah, Matt Moss is on the planning.
What's the population of Cody total?
Yeah, that's a good question. I know they only have 4 wards, I think, reduced down to 3. So the LDS population is about that size. I think Landon can probably look that up.
Yeah, I'll look it up. 3. I thought it was around 15, 20,000.
I think so. But yeah, 4 wards reduced to 3, as I understand. At least that was a couple months ago when we were podcasting. So
yeah, and the only reason I ask is just to understand the likelihood that these individuals know each other, even without the overlap of the bishopric callings. They would definitely know each other in a town that size.
It's 10,224 in 2022. So
okay.
Yeah. Yep, that's exactly right. So, and then there's a little note just saying that, yes, in January, Matthew Moss, no longer a bishop, is on the Planning and Zoning Board. And here's the interesting thing. Between October of 2021, remember that is when the temple was announced in conference, but residents in Cody know nothing, and January of 2022, so that several month period there, the city planner, Todd Stowell, updated 5 chapters of the 11 in the zoning code, Title 10. In January, he dumped it onto the Planning and Zoning Board to review and sent it to City Council for ordinance changes. This was explained as a means of helping create more affordable housing. The city administrator was okay with this. The P&Z board had 3 new members during this initial time, and Matthew Moss was one. So as soon as the temple was announced, coincidence or not, I don't know, the city planner starts making some changes to, it sounds like perhaps, does it sound to you like high density, Landon? Just starts doing
affordable housing is
affordable
usually high
housing,
density
yeah.
because it's usually apartment buildings. But this is what we've heard several times is that the codes are changed when the temple's trying to get in under the guise of, oh, we want
High
affordable
density.
housing. So
Yeah.
you start allowing larger buildings in areas so that they can have apartment buildings. And so, was this related? I don't know, but the timing sure seems very suspicious when you line this up. So
I guess
really
that'd be my
does.
one question is just if any of because typically religious buildings need a conditional use permit, as we talked about in the Fairview discussion we had. So I'd be surprised if any of these changes to the zoning code actually would have affected the temple's application. But I'd have to go double check. So that would just be my unresolved question. I seriously doubt it, to be honest.
Yeah,
it may just
has
be
to
a
do with
coincidence.
precedents and things like that. You have apartment buildings. It's hard to tell a temple you can't have a roof this high because you already have an apartment building there where the codes have been changed. And we've seen the code changed in Vegas. And
what we saw happen in some of the places is they rezoned areas to get multiple density housing, and then they slip something in. So it's hard to know without going through and doing an evaluation, but it just seems odd that the very time that the temple's announced, half the codes is updated right in that time period.
And we've seen this in other cities. Yeah. So again, we don't know for sure, but it's an interesting timeline. Go ahead to the next slide. You can read these, Landon. This kind of takes us up toward the end of where
these updating activities continued throughout 2022 and into the early half of 2023, finishing just ahead of the Temple project application to the city in May 2024.
Right.
In February 2023, Temple modules started showing up on members' property for storage. So they don't have a permit yet. Nobody knows where the temple's going, yet pieces are already showing up in town. March 15th, 2023, the site was announced in the Cody Enterprise, but March 13th, it was released to Church News for the LDS. Note that neither announcement included any specifics about the building. So nobody knows what it's going to look like or anything like that. They just know that they have put a site. March 27th of 2023, the rendering of the temple is released, and in March of 2023, the land was donated officially from a church member.
Right. And it's the same church member who stored the pieces on some of his other property. But again, if you don't even understand what a temple is, you might hear, oh, there's going to be a religious building here. Most people think it's a church. I mean, it's very interesting to talk to these residents as they just start out temple virgins. If that's a phrase, they have no idea. They really don't. They don't understand. So, all right, let's go to the next one. You can finish out, Landon.
Yeah, on May 2024, the Temple project application was submitted to the city of Cody. And June 6, 2023 is when the church PR representative shows up to have a meeting that's required. You're required to have a meeting when you provide a notice. This is the required meeting 10 days before the City of Cody Planning and Zoning and Adjustment Board meet to consider the design, which this is June 6th is the first time anyone has seen a rendering or a design of what the temple's even going to look like. And that June 16th date is very important as we go through the reading.
Right. And this just took you right up to that point. And there are many articles on that meeting. It was Doug Anderson came down from Salt Lake and some others. And the meeting just left the residents just overwhelmed. It was not super friendly, like a lot of these initial meetings that we hear of, where there's kind of alluding to, this is going to happen. And they're just kind of reeling because this is the first time they're hearing about how tall it's going to be. This is a very, very residential. I mean, Landon and I were there. It's just a little tiny street. It's got houses on either side. And there's going to be this, giant building there. And again, proportionally, this is 10,000 square feet.
Yeah, this isn't that large, but it's tall. It's very tall. And it's in a very rustic.
Yes.
These homes are built in a with a Western outlook to them, and that's they're looking for wide open spaces and wide open lands, and now you've got a white marble building.
Birthday cake. And as we understand it, the plan is kind of to build a temple at each gateway to Yellowstone. sort of like a billboard. So, right there, it is very visible everywhere in town. So this is a picture on the left of that meeting. Everybody was there. The blurb says that it was packed. It was a public hearing. But then you have, it seemed like just a back and forth lawsuit, right? Landon, do you want to just very quickly kind of explain?
Well, the church filed the first lawsuit because when the Planning and Zoning Committee got together, they passed the application initially, but there was confusion as to whether the Steeple was part of the packet because the church had put in the application. Then the zoning board said, no, we don't want to approve the Steeple height. That's too tall. We need to revisit that. The city planner, who's LDS, they had removed it for a time, and then they came back and put it back in.
Meaning as far as approval, not actually.
As far as approval, they put it back
you can vote on the site plan. It's almost like the bell tower in Fairview. Yeah. You can vote on the site plan. We'll decide on the specifics of the Steeple. That's kind of what he led them to believe they were voting for. So even among the board members, it was very confusing as to what they had or had not voted for. And again, this is going to be very important when we get to what Kolby's going to talk to us about.
So they.
If I can just.
Yeah.
Oh, if I can just. So on the timeline, we had the hearing date is June 16th. It's actually June 15th.
Yeah, it was the 15th. Yeah, that was a little typo. So you're right. It was the 15th.
So
no worries. Just because we're going to return to that date.
So it's only 9 days notice then.
Yeah. So, even worse, only 9 days notice. That's right. Yep.
So there was confusion about this, and only three P&Z members voted for it. Right. 2 voted against. And so there was some confusion as to whether it had passed. And
was this the meeting that there were some members missing?
There were members missing, and the state law says that you have to have a majority vote of the board. And so they said, well, we don't have a majority of the board because some were missing. So it didn't pass, and that's when the church filed a lawsuit and said, no, you passed it when you only had 3 people on there. And then there was all the argument, well, even if it passed, it didn't pass with the Steeple. And they said, oh, yes, it did, because we put it back in after we had withdrawn it. So
but no one on the board understood that. And the residents there, as they go through this process through the next year, trying to file these, different things saying, hey, there was some kind of irregularities. They use the Freedom of Information Act to get thousands of emails, and they have emails between people in the city on the board saying, did we vote for that? What was that? I'm not sure. There was confusion, but in all the court cases they were part of, they were never allowed to use any of these emails that they had gotten. So, but we've seen them, and everybody was really confused.
One other item is one of the Planning and Zoning Board members had to recuse himself because he either worked or owned a firm that did site surveys. He was a surveyor, and his company was hired to survey the temple site, and therefore by the church. So they said, well, you have a financial interest because you're going to get paid to do this. So he had to recuse himself. However, the city planner and the member of the board who had been to the temple and had sworn an oath of obedience.
I'm having trouble hearing you.
To the church, they did not have to do, or they did not, because they said there was no financial interest.
Yeah,
even though
it's hard to help people understand that there's sometimes something beyond a financial interest to get something passed at all costs or do what it takes. And of course,
in fact, in all of these that we've done, Heber, you had all LDS board. Here you had one person on the LDS board. What we find is not a single LDS member has ever voted against any of the actions that the church has, even with these numbers of people concerned, they've always voted with the church.
In fact, in Heber, some of the people on the county commission were right there with a golden shovel right next to President Nelson. And when we would have residents there kind of stand up and try to talk in these meetings, members of the council will say, why are you against what we're trying to do? And it makes you say, who's we? Aren't you a government entity? Who are you speaking for? Who is we right here? So anyway, it gets pretty interesting. It looks like we lost Kolby for just a minute, but we'll kind of continue. So you can get this idea, that the residents are saying irregularities. There's something not right. Nobody knows what they voted for. Steeple, no Steeple, did it pass? And this is why they formed the Preserve Our Cody Neighborhood group, to try to just see if they could get some clarity here, whether that had to be through legal means or whatever. And of course, then the church is suing back, and we start to get these headlines, which I don't know if we've seen before, about the church and temples, where it clearly says, this is just one example. LDS rep says further litigation will cost city. There are other headlines even more blatant, saying LDS threatens to sue small town into oblivion, things like that. So there was definitely some headlines that came out that I hadn't seen anything like that before. The city planner in this article, he came under scrutiny pretty early for statements like this. You want to read that, Landon, where he's actually, in my opinion, from this, trying to influence what some of the planning and zoning board members will do. Kind of almost a warning to me, it seems.
Yeah, City Planner Todd Stoll included a warning about potential legal consequences if the Planning and Zoning Board decided not to accept his findings about the height of the proposed LDS temple. If you do not personally agree with the city attorneys or my interpretation of the Cody, Wyoming Temple of the Church of Jesus Christ of Latter-day Saints complies with the building height requirements of the Cody zoning ordinance, please prepare to be directly questioned in court to explain your logic and conclusion and why it is any more sound than that presented by your staff, legal and planning, he wrote. This is not meant to be threatening, but simply letting you know the strict scrutiny to which your personal decision will be subject. They always seem to say
Kolby?
that.
Yeah.
Well, immediately, and I understand that a city planner is probably not an attorney, but immediately, in our discussion on the Fairview Temple issues and that we had just a few weeks ago, we talked about the strict scrutiny test. So when I see someone talking about legal consequences and using the word strict scrutiny is a test, as we talked about in that last episode, that's applied to governmental action when it infringes on one of the most important constitutional rights. So honestly, that's just nonsense. That's just nonsense. That decision would not be subjected to strict scrutiny. And while I'm not familiar with the exact requirements of, Wyoming law, they're entirely within their rights if they have a good reason. I mean, he's right, I guess, generally, that they need to have a reason that they're generally going to disagree with staff's conclusions. But to do it in this way, particularly with, his personal relationship with the church, definitely is over an ethical line that I myself wouldn't cross, advocating for a group that I'm a part of. Sorry, I had a connection issue for just a second with my AirPods. And I did want to touch on one thing you had talked about, the potential conflict of interest. And so since we're talking about it now, I guess one of the things that I'd highlight is typically, and again, I'm not licensed in Wyoming, so I don't know all of Wyoming law, but typically conflict of interest laws, when it concerns public employees, they typically only are concerned with financial benefits that are directly conveyed on people. And so you're right, it's just kind of a hole in code that more people probably need to understand, particularly when you do have, member, and I'm not trying to be offensive, but you do have members who have literally covenanted to give everything they have, including their very lives, for the building up of the church on the earth. And then we're seeing behavior like this that I think is kind of inexplicable on why they would be pushing so hard. To me, it would really raise the question of, like, who are you really working for here? Are you working for the church to further its goals, or are you working for the city of Cody? Because the city of Cody was paying your salary, and you're supposed to be, furthering that public interest, not the church's private interest.
Yeah.
And that's exactly what happened here. Yeah.
And that's the sense I think the people in the town started to get. They started to say, what is happening? And I know with this particular sort of threatening line here in this newspaper article, we did hear that some members of the Planning and Zoning Board were very intimidated, were very worried, were very upset, even felt like I just voted because I was upset, I was concerned. And so definitely people started to get this idea about the city planner, that there might be something going on. And of course, like I said, our residents there, thousands of emails, and there is correspondence between the stake even before the city, right, Landon? He would sometimes give information about meeting changes to the church before he would talk to his own people about it. And then his own board members would go, wait, why are we changing the meeting? And he had already let the church know that it was changing. Things like that, where you just really question exactly what you described, Kolby.
And the steeple height was one of those issues because, what the argument was is that steeples don't count towards the height of the building. Yes. Therefore, his point was that the steeple didn't count as overall height. So the thing is a steeple, if it's sitting on top of the building and is not supported, is not structural, then it doesn't count, I guess, was the way people were reading it. And so they looked at the pictures of, I think it was the Casper temple that was being built at the time, and they said, wait a minute, this is tied into the structural still of the building. So if it's tied into the structural still of the building, it's not a standalone steeple. Doesn't it then count as part of the building? And he never responded. And we had emails going back and forth with the commission asking him, please clarify this for us. And he wouldn't clarify it. So we saw later emails where the planning and zoning board felt like they were being manipulated by the city planner to get this through, which all of us who are LDS would absolutely understand, that that your number one duty is to your religion to get this through. And that's the point of view that the people had of what was going on here.
Yeah. And again, kind of flying blind, like they really don't understand what we innately understand or grew up in or experienced. They really don't. So another thing that came out from some of these documents from the Freedom of Information, and this is all in the papers, this is nothing that we're saying off the cuff here. The person who donated the land, who was storing the modules, there's a picture of them right there in the top corner on his land, offered Todd Stoll a job because it was getting kind of heated. People in the town were reading all these articles about what Todd Stoll was doing as far as manipulating possibly things behind the scenes. So in the Cody Enterprise, it says city planner says he has not responded to the text in any manner. This is true. There was not a response, but there was a text through the Freedom of Information Act where donor Glenn Nelson texted an offer to planner Todd Stowell. It's included as an exhibit in the October 23rd brief submitted by Preserve Our Cody Neighborhood, the group opposed to the temple's location. And the text basically says, I guess we don't have a copy of it here, that if things get too heated, remind me if I'm wrong, Landon, you'll always have something with me. Isn't that kind of what it says?
Yeah, there's always a position for you here with us.
Yeah. And it's in this, if anyone wants to look it up, I'm sorry we don't have the exact text. It is in this article with that title in the Cody Enterprise. But yeah, you'll always have a position with us. And of course, Todd said, I didn't respond to that. But just the fact that there it is, kind of like, you're doing something for the church. I know it's hard. You're doing it. We'll help you. So then the next thing we know, and of course, throughout all this, there's back and forth. The Preserve Our Cody neighborhood is doing things. The church is doing things back and forth. And then suddenly the city planner Stoll steps down on February 15th in 2024. He says his resignation is not connected to the controversy surrounding the proposed LDS temple, but he just flat out stepped down very quickly. And I think we have a statement next. Maybe you can read that, Landon. We're kind of getting to the end here, and then we'll move on to Kolby.
After more than a decade on the job and after a year that saw him fall under intense public scrutiny, Cody City Planner is moving on. Todd Stoll submitted his resignation Tuesday morning and plans to leave the city post in early April. Stoll publicly announced his departure at the end of Tuesday's Planning and Zoning Board meeting, making a point of saying that this decision was totally voluntary. Let it be clearly known that I have not been asked to resign either directly or indirectly. Neither is my resignation due to the current litigation surrounding the Cody, Wyoming Temple of the Church of Jesus Christ of Latter-day Saints, Stoll wrote in his letter of resignation. I simply desire to serve others in a different opportunity and focus more on my family. That's important words. We're going to come back to those.
It is important words, and it left everybody kind of scratching their head going, what is happening? I mean, it left the city without a planner right there at this pivotal time. And everybody, especially our residents, wondered, well, where is he going? What is he going to do? Yeah. Okay. So I guess we'll go back one because then we move to the next. So we kind of dug in a little bit and we didn't really figure anything out till probably about how long ago do you think it was, Landon?
We probably about a
3
month
weeks
ago,
ago.
I guess.
Yeah.
Yeah.
Yeah. So we learned that Todd Stoll and his wife were called on a mission to, let me see if I can read this correct. Yeah. Kenya, Nairobi East Mission, working as a financial secretary and somebody in the mission office, kind of that sort of a position. So he quit his job with the city, and within, let's see, the mission was just created, I think, brand new in June. Yeah. So February, March, April, May, June. So within a few months, he's no longer in Cody and he's serving an LDS senior couple mission in Kenya.
And this is pretty amazing because if you look at him, he does not look old enough to be a senior missionary. He didn't retire from the city.
No.
He quit. So he quit his job after, saying he wasn't representing the church or wasn't favoring the church in any way. And he leaves on a mission for the next 2 years, unpaid, where he's going to have to pay for himself and his wife. This just, I don't know. It doesn't make any sense other than he's getting out of town. We were looking to see, is the church going to take care of him somehow? And all of a sudden he ends up on a mission in Africa. Now, maybe that's what he was talking about. I guess that's what Mormons mean when they say they're going to focus more on their family as they're going to leave on a mission for 2 years. It sounds like he made a decision to leave on a mission to serve the church after all of this, where he was being accused of helping the church. That just seems like very bad optics at that particular moment to make that decision. But that's what happened.
Yeah. And we don't know too much more than that, but we'll just throw it out there for what it is.
I'm just smirking a little bit at your cynicism, Landon. He said directly that it had nothing to do with the litigation surrounding the temple. So,
that's right.
You
got to take him on what he says. That's right.
So you're so cynical there, Landon.
That's right.
I know.
People just normally, when they're nearing retirement age but aren't yet there, probably a decade off, just up and go to Kenya. That's just what people do.
It does seem odd. I've seen people do this who have worked for federal government and have 30 years in and have a retirement, and they can, but a city planner, and he said he'd only been with the city for a decade. You don't get to retire from city service after 10 years on a job. So, and we know he didn't retire. We know he quit. And so just seems a strange personal decision to be making when you're under all this heat and pressure, and the townsfolk are up in arms about thinking that you were working for the church behind the scenes, to quit and then basically go work for the church. I know it's volunteer, but he's not getting an income and he's paying the church to go work for them. So,
or maybe it's funded. We don't know that either.
There's could be funded. In fact, that's an easy way. People can say, hey, why don't you go on a mission? Thanks for all the temple work you did. We'll make donations to the church to help cover your mission costs.
Kind of get out of Dodge. Get
now,
out of
he's not getting it personally. It's going to the church, and then the church turns around, puts it in their account. I don't know. Is this possible? I don't know how that works with senior couples, but it sure looks like a way that you could reward somebody without actually having to put money in their pockets.
We do not know. We have no idea. I think that's just a speculative statement.
Just speculation, but it certainly raises questions. So let me put it that way.
You both are just so cynical. I am just sure that they needed the expertise of a small town city planner in Kenya. That's what I'm guessing.
Okay, you're right. We're way more cynical than you are, Kolby. You see it so differently. So you're right. So there was. All right. As we finish,
it's reminding me of one of my favorite Monty Python quotes, which is "Hold the other one."
That's really funny. Go back one more, Landon.
Oh,
that's funny. So there was then a final hearing, and this happened in May. And believe it or not, Todd Stowell showed up to this meeting, which everybody thought was really interesting. Nobody really, at all the other meetings they've had, the residents have been out in force, they've been doing what the church does so well, getting everybody out. But at this particular hearing, I think our residents said there were about 20 of our residents, and then just Todd and his wife and the lawyer, I think is who they said showed up. So anyway, so it says judge entertains temple arguments. The future of the proposed LDS temple in Cody awaits the decision of District Judge John Perry of Gillette, who said he was taking the matter under advisement on Thursday, May 23rd. His pronouncement came after the final hearing on 4 different lawsuits, 2 filed by the Church of Jesus Christ of Latter-day Saints and 2 by the Preserve Our Cody Neighborhood group. 2 Sheridan lawyers represented the 2 sides. Deb Wetland for the POCN and Kendall Hoops for the LDS. The neighbors say the proposal violates the city's zoning regulations and that the actions by the Planning and Zoning Board were flawed. The church says the temple and its 100-foot tower comply with the city rules and the P&Z Board's actions were proper. So that's what was placed in front of the judge. And then we all waited. May, June, July. And in the meantime, while we're waiting for this ruling, back in March, Cody, as I alluded to before, tightened up its conditional use permit procedures. So I can't remember all the details, Landon. They definitely made that notification period longer. They made it so there had to be a super majority on the Planning and Zoning Board. They just made it, and also the notification area was supposed to be increased so more people would be aware of what was happening. Can you think of any other parts of that I'm missing?
No,
But they tried to shore up their town against
they tried to
stuff
shore
like
it
this.
up. Yeah. And that's the same thing you saw in Fairview, that if the P&Z board does not approve it, then it takes a super majority of the city to
And they had that in place already. So that ruling, everyone's waiting for it. And that's where we take us to last Monday, the 26th, where suddenly our residents let us know that they, through their attorney, had been given the results of the ruling. And there it is. So at this point, Landon and I are going to go get popcorn or ice cream or something. And we're just going to let Kolby do what he does best and help us understand what this ruling is and what it means.
Great. Do you want me to share?
Yeah, I think Kolby needs to share screen here. Yeah. So, and again, there's so much more to this saga, and we have so many podcasts on it, but we hope we gave you just a little sense of what was happening, the back and forth, so the ruling will make more sense to you.
It does, and I haven't even followed this as closely as you both have, obviously. I just have read the decision and followed some of the reporting that you both have done. So I'm really grateful for that, and I'm grateful for the context, because it does make some of the things make a little bit more sense. So let's talk about the court decision. That's why I'm here. So as you said, Rebecca, the court took the matter under advisement. That's pretty standard. That just means that the judge is going to go do some research, take a second look at probably the writings that were submitted by both parties. Believe it or not, even though it's a lot of pressure as an attorney to get up and argue in front of a court, most decisions are made off of the written materials, not off of, who can quip better at an oral argument. That's just simply not really the way our legal system works, believe it or not.
It's not like on TV where the lawyer can get up there and make the impassioned plea and it sways everybody, including the judge. And
yeah, very rarely. There's no Miracle on 34th Street reality when it comes to
no mail
the
thrown
actual
on the
legal world. Yeah, and my other one is always like surprise witnesses. Like there's no such thing as a surprise witness except in like the rarest of rare circumstances. Like there's notice that there's due process problems that would happen with that anyways. So as you said, the judge took the matter under advisement, and I think I wanted to briefly just talk about how we got here in the sense of like legally what was being challenged. And so you can see right here at the beginning, these matters come before the court upon the filing of a petition for judicial review by the church on July 17th. So that was the first lawsuit, just 2 days after, or I'm sorry, a little bit after a month after the June 15th meeting. And then there were a bunch more petitions for judicial review, 4 in total that you can see are mentioned here in this first paragraph. So some by the Preserve Our Cody Neighborhoods, which throughout the decision will be referred to by the acronym POCN. And then the church also filed multiple petitions for judicial review, one on July 17th and one on July 27th. And we'll talk about the arguments and how the court adjudicated them. But first, I wanted to start and talk just at a high level of what a petition for judicial review is. So in administrative law, which is the type of law where, you're dealing with the government or some government agency making a decision, including like local government agencies like we're dealing with here, whether it's a city, town council, or a planning and zoning board, those decisions can be ultimately reviewed and appealed directly to a court to verify whether the standards that need to be followed have been followed. And that there's basically like model statutes. We talked about this a little bit in the Fairview discussion that we had when we talked about state analogs to the Federal Religious Freedom Restoration Act, state analogs to RFRA. We have a very similar situation where we have model statutes that provide for this type of agency review. They're typically in each state going to fall within their Administrative Procedures Act. So again, I don't practice in Wyoming. I'm not licensed in Wyoming. But as I look at the statutes that are cited throughout the judge's decision, it looks very similar to the Idaho Administrative Procedures Act, which I'm very familiar with. And those laws typically went into place in the late 80s, maybe even the early 90s, when we saw more and more state administrative agencies cropping up and questions of, what's appropriate for them to resolve. So in a typical case, administrative review through a petition for judicial review will also include local government units. And so we can see that that's the case here, and all the sides filed petitions for judicial review. So as we go through the decision, the judge provides a factual background. You have provided most of it already. The one thing I wanted to highlight is that there were four meetings that happened that touched on the temple. So we talked about the first one, which was on June 15th. And here's how the court summarizes what happened at that meeting. It says, quote, "The board held a public board meeting on June 15th, 2023, during which it considered the church's CUP application." So we talked about this in our in our Fairview discussion, but a CUP is a conditional use permit. It means that the church is asking, because it technically doesn't fall within the scope of the permitted uses in that zone, because this zone is rural residential, they have to receive a conditional use permit. That's a little different than a variance, but a variance is basically asking for some wiggle room in the standards. So CUP is a little different. It has to do with the use, but that's very standard, as we've talked about in our Fairview discussion, for religious buildings like a temple. So the decision continues and says, members of the community were present to provide comments in favor and against the proposed CUP. Members of POCN, which is the residents group that you've been working with, as well as their legal counsel, provided comments during the June 15th, 2023 public meeting. The meeting was lengthy. The record reflects that anyone wishing to speak was given the opportunity. And the judge's footnote there actually says that the meeting lasted for more than 5 hours, and that there's a transcript of that the judge reviewed as part of the filings for this case. The next meeting that the court talks about, or I think I should finish this next paragraph actually. At the conclusion of the June 15th, 2023 public meeting, the board voted on a proposal to approve the site plan. The proposed site plan, including certain conditions that were recommended by city staff, and that's probably includes Todd Stoll's recommendations. Of the 5 board members present for the vote, 3 voted to approve the site plan, 1 voted to deny the site plan, and 1 member abstained from voting, which you talked about had to do with conflict of interest rules. Believing that a majority of the full 7-member board was necessary to approve a site plan, the board chair concluded that the motion failed and elected to table the site plan review for later consideration. At the same meeting, the board passed a motion to approve the church's CUP and issued written findings of fact of the conditional use permit. POCN did not file a petition for review related to the June 15th, 2023 approval of the church's CUP. And you may be wondering, why does that last part matter? This is a little bit of foreshadowing, but that's going to cause a huge issue down the road for the residents' concerns on this CUP.
Yeah. And how could they know, again, like Landon said, how could they know at that point that that was something that they need to file within such a short period of time?
Well, the problem is the board chair said it didn't pass.
That's exactly right.
So why would you appeal something that didn't pass when that's what you wanted?
Yeah.
If it didn't pass, and maybe you're more familiar with this, but if it didn't pass, because this procedure to me is really confusing. And it makes no sense how this happened with the city's legal counsel, to be completely honest. But setting that aside, why would the board have approved written findings of fact on the conditional use permit if it felt it hadn't passed? Do you remember from listening to the meeting or from any of the
I don't,
discussions
but
you've had?
you can approve the site plan with conditions,
Right. Like the bell tower.
and which you can say you can build the 10,000 square foot, 20-foot tall, 30-foot tall temple, but you can't put the 110-foot
Right.
spire on top of it.
Yep. None of them thought they voted for the spire.
I believe that's what was going on. But as you can see here, the board chair said that it didn't pass. He concluded that it didn't pass because they didn't have 4 votes, which would have been a majority of the 7 board member, because they had members that weren't there. So he said it hasn't passed. So they gave him the cup, but they didn't approve the site plan. So you get a conditional use permit, but all the conditions aren't met for the steeple.
Details about the steeple. Yeah.
And that's what they were concerned about, was this steeple height. So the neighbors said, oh, it didn't pass.
Yeah.
Good.
Exactly. And now you can kind of sense why they're so devastated as we go through this, because literally it was over right there, according to this judge. And everything that they did over the next year, you know, the back and forth, the different things, none of that meant anything. They needed to have done something within 10 days. And yet they thought it had not passed. So why would they even worry?
Why would they do anything when they thought it didn't pass?
They're so devastated over this. Yeah.
So.
Yeah, I suppose I'm just very confused on how the city's legal counsel got here based on reading the rest of the judge's decision, because it feels like if anyone should know the rules on when something does and isn't considered passing, it should definitely be the city. So I can completely understand the residents' concerns that the city's mistakes and procedural errors led them to think that they had more time to appeal, or that they didn't have to appeal this specific order. But anyways, I'll continue.
And I will say this, the city attorney also, although not LDS, seemed to be working hand in glove with the city planner. We heard this many times, didn't we, Landon, that there was some undue influence there too, as far as paying more attention to the LDS Church's agenda, things like that. Nobody could really understand it, but there was a lot of things happening behind the scenes that seemed to be confusing to this P&Z board, who honestly thought, we're voting for the site, go ahead, but we're going to work it out later. It sounds just like the bell tower, doesn't it? We'll work out that height later.
We saw in the after all of this happened, they did a Freedom of Information Act and got copies of the emails and the letters that were going back and forth. And we have a copy of Todd Stoll saying that the LDS member on the board said, did we pass it?
Yeah,
and he
flat out asked, did this pass? I don't know.
Last night I found a way to that this passed, and I just got goosebumps as the Spirit moved me. So Todd Stoll had found a way to make the interpretation that it had passed. And I can't remember if that was after this one or after the city count.
Right.
Well, it would have been this one because it was the planning
and zoning. The board was confused. Yeah. The board itself was asking,
members themselves,
even the LDS member, what happened? And Todd's saying, I reviewed it. I slept on it. The Spirit whispered to me. I figured it out. It passed. So you can see why the residents are just devastated, confused, hurt.
Yeah. And I don't mean to disparage the city attorney at all. I guess I'm just having served in a similar capacity where I've had to advise, lay people that comprise a board. It usually takes a little bit more hands-on management than it might with, people who've been doing it a long time. You said that 3 of the members on the board were new. I'm not sure how many of the new ones were at this meeting that only included 5 versus 7. But that part is a little confusing to me, how the city or whoever was advising the planning and zoning board wasn't clearer on exacty what they were voting on.
I believe the fact that they weren't clear on what they were voting on, it was very much part of the citizen group's issue was, and the planning board. They said, we weren't sure. We thought we were voting on it without the spire. And yet now we were told that the special request was pulled, and that's how he was able to say now it passed. But the issue went further than that, just because that there was a lot of confusion, because there was two different laws. One said the majority had to pass, but the state law says a majority of the entire board must pass. So they said the state law supersedes our law. It has to be a majority of the board. And evidently the judge disagreed and said it's the strictest of the two, which would be the smallest number of, the majority of those that were there.
It's very hard to follow. It's a cautionary tale. I'll say it again, to any town: shore up your ordinances, your rules, your codes, make it clear so these kinds of things don't happen. But I guess you don't really know that until something like this does happen.
Yeah, unfortunately, that is the way it happens sometimes. Is, that's one of the things about being an attorney sometimes that is frustrating, is a lot of times I'm stepping into a problem that's already been made, and I can't go back and fix it, when if I knew on the front end, it's a lot of times it's a lot easier to fix. So I guess going back to the substance of the decision, there are 3 more meetings. So we've talked about this June 15th meeting, where ultimately and we'll talk about it in a second, we've already kind of hinted at it, ultimately the judge is going to find that everything basically was approved according to what the church wanted at that June 15th meeting, and that any action the Planning and Zoning Board took after that fact was basically a nullity. It basically, because the church had approved and I'll scroll back up for a second, because it says right here, the proposed site plan included certain conditions that were recommended by city staff. And so the judge is going to ultimately view the fact that the three members, the majority of the board that was present that day, voted on this, rendered the CUP basically valid, and that the church was entitled to what it had. But they didn't know that at the time. And so on June 27th, 2023, there was another agenda item where the board considered or asked to reconsider and amend the findings of fact for the conditional use permit. So we see some changes to the steeple height, and they also asked to just generally reconsider basically the entire thing at this meeting. And so that's basically what happened. And then that decision leads then to a subsequent meeting on July 25th, where the board looks at amending to find that the proposal was consistent already with height regulations. So I'm guessing, Landon, with the background you added about steeple height versus like a separate steeple, and the questions that are unresolved with that, it seems in the city's ordinances, that seems to be what was going on here, that they were looking at either the roof height or looking at the steeple height, and specifically looking at that particular issue. And then they didn't finalize things there. There was then a 4th meeting on August 8th, 2023, that sought to amend to add additional conditions on light pollution, to limit light pollution. And I know that was one of the residents' big concerns. I think it's important to note that, and the court notes it here as well, that the POCN, the residents group that you've been working with, they appealed both the decisions coming out of the July 25th meeting, as well as the decisions coming out of the August 8th meeting. And so they did preserve their appellate rights on each of those. Before we talk more in depth about the judge's reasoning, which actually isn't that long, I did want to just, because one of the reasons I do this is I like talking about the legal field and helping people understand maybe the method behind the madness. Sometimes I know that sometimes it can feel really intimidating. And particularly when we're talking about appellate stuff, one of the things I wanted to share is what this concept of a standard of review is. So when you're looking at an appellate decision, which a petition for judicial review is a type of appellate decision, you'll see this word used, or this term used, a standard of review. And I wanted to share this quote, which actually is from an article I wrote several years ago, talking about appellate practice and talking about standards of review. A few years ago, I wrote this: a standard of review is a guideline used by an appellate court to examine a trial court's decision. The standard of review also determines how much deference an appellate court will pay to the decision of the trial court, which may have a large impact on the chance that an appeal will ultimately be successful. Recognizing when a particular case may pose an uphill battle because of the applicable standard of review is an inherent characteristic of a competent appellate attorney. And that's just that's in a piece that I wrote a few years ago for Idaho's attorney trade publication known as The Advocate, which I serve on the board for. And one of the reasons I wanted to share that is because there is such a misconception about what appellate courts do. They aren't, when you're pursuing an appeal, it's not just a second chance to argue your same facts or your same evidence in front of a different judge or a panel of judges. In fact, the Idaho Supreme Court has 5 members. Our Court of Appeals has 4 members. When you're dealing with an appellate court, you're typically going to be arguing to multiple judges or justices. And they're looking at very specific things. And the reason I wanted to explain that is because I know, and I'm not at all trying to take away from the residents' concerns, but I want to highlight the reason that I think the judge probably had to reach this decision based upon the legal authorities that he cited throughout this decision. Again, with the caveat that I don't practice in Wyoming law and that the POCN group is reviewing its options on whether they think further appeal is warranted. So I want to get those caveats out of the way. But I do want to explain why I think the judge had to basically reach this decision. And it has to do with the really, really difficult standard of review. So in our last discussion, when we talked about Fairview, we talked about a very easy standard of review. We talked about strict scrutiny, which is when the government is imposing a burden or a substantial burden. I'm sorry, I need to be really careful with that because it is substantial burden. A substantial burden on someone's sincere religious beliefs, then the government has a really, really high burden. And so it can be very easy on appeal to have that decision overturned, potentially, right? If you're able to actually demonstrate that it's a substantial burden. Other examples would be like a type of discrimination based on race. That's also going to be reviewed for strict scrutiny. And so the higher the burden or the higher the level of scrutiny, the easier it can be to prevail on appeal. And standards of review aren't exactly the exact same concept, but they're very similar. And so that's why I wanted to talk about this. A standard of review is basically looking at how much deference are we going to give the trial court or here, the administrative agency, which includes the local government units. How much deference are we going to give their decision? And the bottom line is here, if we look at this Wyoming statute that the court provides, he actually has very limited scope of review here. So he can compel agency action that is unlawfully withheld or unreasonably delayed, or he can hold unlawful or set aside agency action, a finding and conclusion that is found to be any of the following: arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law, contrary to a constitutional right, power, privilege, or immunity, in excess of statutory jurisdiction, authority, or limitations, or lacking statutory right, without observance or procedure required by law, or unsupported by substantial evidence in a case. And so those different 5 things, like I said, are a very common standard of review that you'll see in administrative agency decisions. And I think what I wanted to highlight is that this is a very high burden. So if you look at each of these things that it can be set aside for, to set aside a decision that's arbitrary and capricious, that means there basically has to be no good reason, even a hypothetical set of reasons that the decision maker could have made their decision. That's a very high burden to assume and to attempt to show. Contrary to a constitutional right, we've talked about that. That's also very difficult depending on the constitutional right we're talking about. In excess of statutory jurisdiction, that means that the local government unit would have had to do something that it's not authorized to do, either by state statute or by its own ordinances. The 4th one, without observance of procedure required by law, is also very similar. So say there was some notice ordinance that required the city to provide some level of notice before it could vote on something like this, and it failed to do that. That's one of the ways that the court could then unwind this. And then the last one, unsupported by substantial evidence in a case. Remember that this statute is going to apply broader than just review of local government actions or zoning decisions. And so that would actually apply more in a case where we're dealing with, a court or a lower agency actually finding specific facts. I'm not saying that didn't necessarily occur in this case, but I also think when people see the word substantial evidence, they think it means more than it actually does. And in fact, the court kind of highlights that at one point in this decision. Well, the rest of this standard review section really just highlights what I'm talking about, where he says the Wyoming Supreme Court has established that reviewing courts apply the substantial evidence standard in contested cases with the added safety net analysis under the arbitrary and capricious standard. However, reviewing courts apply only the arbitrary and capricious standard when reviewing agency action resulting from informal non-contested case proceedings. Again, this is some legal jargon that has to do with the delineation between the types of cases. And so it is a little bit technical. What I really wanted to highlight, though, is that this is a difficult bar to overcome, and that understanding the governing standard of review before an appeal is pursued is something that is a really difficult part of appellate practice. It's what will shift. Like I've had this type of a conversation with people who've called me about potentially taking on an appeal, where I basically say, okay, well, let me look at the applicable standard of review, see what the case law says. And if it's a really difficult standard of review that gives the lower court a lot of discretion, even if I think the decision might be wrong, it's not necessarily something that I'll be super excited about appealing, if that makes sense. Do you have any questions on this notion of standards of review before we move on to the rest of the decision?
It sounds like you're saying if it's not wrong enough, they can't overturn it.
Yeah, and I think that really comes back to my earlier comments about what appellate law is about. Appellate law is typically about finding some legal error. If we look at these 5 delineated factors, almost every single one of them has to do with a legal error, not a factual error, right? It has to do with, hey, the law required you to provide this notice or this procedure before you voted on this, and you didn't. That's not a factual question. I mean, it involves a factual question of did it happen? But that's a legal question of did you comply with the law's requirements? It's the same thing when we're dealing with the arbitrary and capricious standard, which the flip side of that, we talked a little bit about our levels of constitutional scrutiny, would be a rational basis. So as long as there's a rational reason for a decision, which that is a very deferential standard. In fact, just a fun little factoid for your listeners, one of the few cases where the Supreme Court of the United States has overturned a rational basis, overturned a statute on rational basis grounds, actually comes out of Idaho. It's a case called Reed versus Reed. And I think it was overturned in like 1958, if I remember correctly. I'd have to go look it up. But what it boiled down to was Idaho had an intestacy statute, or a statute that appointed an administrator of an estate if someone didn't have a will in place or an estate plan. And what it did was it drew all these distinctions of the people that you would go find to act as the administrator of an estate. And at the very end of the list, so it basically like start with the closest related, the oldest, and then when you got to the very end of the list, and again, we're dealing with a statute that was written a long time ago since it was overturned probably in the 50s, it ultimately, if it came down to you had 2 people who were just as related, who were the same age, it selected male heirs over female heirs. And that was held to be violative of rational basis, saying that there's no legitimate reason to view men as inherently better at administering an estate than women. And so there was no legitimate reason. I only bring that up just to highlight how deferential this rational basis standard of review. And that's basically what the court was reviewing, at least in part here, is the flip side of a decision that's arbitrary and capricious is a decision that's grounded in rational basis. So again, I know these legal terms can be a little bit wonky and a little bit, can seem a little bit difficult to wrap your head around. But that's, again, kind of the method behind the madness here.
No, I appreciate that explanation because that does make it pretty clear. And I like what you said too, Landon, not quite wrong enough. That's the sad reality, probably.
No, that's such a good way to put it. I mean, even going back to those comments I wrote in that article from a few years ago, I talk about how there are some standards of review that are an uphill battle. Frankly, there are some standards of review that unless I have the absolute best facts possible that I could use to articulate, even though I love appellate law, I'm not going to take an appeal that I don't think is meritorious and that I think is grounded in what we have to demonstrate ultimately to, whether it's the Supreme Court or the Court of Appeals, to demonstrate to this reviewing court, this appellate court, to actually have them recognize that. Again, the focus of an appeal is legal error, typically, not errors in the facts. And so turning to the way that then the court ultimately resolves the questions that it had to confront, if people want to read more in depth, they can, again, and we're showing it here on the screen, they can read all of the issues that the court reviewed. And this, I think, actually is a better statement of what the different sides were arguing than the news source that we were looking at earlier, because it actually got some of the things I think a little bit wrong, probably just because they're probably not legally trained or anything. And I completely understand why they might get it slightly wrong. But what this shows is what the judge was asked by the different sides, basically. So it says, petitioner, the LDS Church presents the following issues for judicial review: whether an affirmative vote by 3 of the 5 board members in attendance at the special board meeting held on June 15th, 2023, constituted approval of the site plan submitted by the church. So that's the first question, basically, that the court is grappling with, that the church presented to it in the various petitions for judicial review. One last little piece, since we've talked a lot about the context behind this, and again, I haven't looked in depth at the Wyoming statute beyond what's cited here in the decision, but in a typical agency review action or a petition for judicial review, what the court can look at is usually very constrained. So I'm not sure if you heard from the residents on if they tried to present information related to the information they got through public records requests or through FOIA requests, but I'm going to guess that the judge wasn't even allowed to review that information. Do you know?
There were some cases before where he did not grant any of it. None of it could be used ever. So
yeah, and the reason for that typically is because when you've got an agency decision, the court is typically only tasked with reviewing the agency's record upon which it made that decision. And so if those matters weren't put in front of the court, and of course, how could they have been at that point, right? Because they wouldn't have had that information
right
at that point. But that is one of, I guess, the legal limitations that's imposed kind of by these statutes is, in a typical petition for judicial review case, the court can actually only review the agency record. And so I'm guessing that may be one of the reasons that the residents struggled to get some of the information in front of the court that they wanted to. That's one of the reasons that they may be looking, instead of just appealing this decision on the petition for judicial review, they may be looking at other alternative options and remedies that they can use to try and get those arguments in front of the court, particularly with the weirdness of the procedure and some of the things with the city planner. Those would be things that, you may present in a different type of proceeding, like a writ of mandate proceeding or a writ of prohibition proceeding. Those are extraordinary legal proceedings that are rarer, more difficult to wrap your head around the procedure. And truthfully, I don't even know if that's a thing in the Wyoming courts. It's just something that we deal with here in Idaho. Anyways, going back to the issues that the church presented, the church also basically asked the court to decide whether the board erred as a matter of law when it determined that the motion to approve the site plan at the June 15th, 2023 special board meeting failed for lack of majority of the full board. So this is really just a follow on of their first question, is were we approved at this June 15th meeting? Then the second is whether the board was without legal authority on June 27th to reconsider and amend the findings of fact for the conditional use permit approved on June 15th. So that's basically saying, if we were approved at this June 15th meeting, could the board have even done anything beyond that point? And then the fourth issue raised by the church was whether the board was without legal authority on June 27th to reconsider and then table the site plan that was approved on June 15th. The residents group presented the following two issues. Is the July 25th, 2023 Planning and Zoning Board decision granting the church a CUP to build 100 foot and 11 inches. Why didn't they just go with 101? I don't understand that.
Just had to make
when
it
you're building
1 inch
something
more, right? Like the slogan in
when you're
Fairview,
building
not
something
1 inch more.
When you're building something over 100 feet high, I'm just so confused on why you wouldn't just round it up to 101. But maybe that actually has to do with the height requirements in the city. I don't know. And then the second issue basically has to do with the August 8th meeting. So both of them basically are questioning whether the Planning and Zoning Board's decision was correct in granting the church's CUP at the July 25th and then the August 8th meeting. I know we've gotten a little bit in the weeds, but I think the discussion can go a little bit faster. essentially what the court resolves is, or the way that the court resolves things is, first it looks at the June 15th meeting, and what the court ultimately concludes is that based on Cody City Ordinance 9-2-3, that language provides that, quote, the issuance of a permit shall be conditioned upon the applicant receiving an affirmative vote of the majority of the Planning, Zoning, and Adjustment Board members in attendance at said meeting. And one of the things that and this is why I was asking the questions about, like, how did this even happen? Because if I were advising the city, this would have been what I thought governed. But you were saying, Landon, that you think there's a state statute that's more
that's what I heard, was there was a state statute that said it had to be a majority of the body that was there. Now, whether they knew that at the time, I don't know, but for some reason the director or whoever's over the Planning and Zoning Board was under the impression that it had to be the entire board.
Interesting. One, I guess, little note is this specific city ordinance that the court points to actually doesn't apply to residential buildings or to houses of worship. It actually applies to commercial buildings, but at the same time, the court says that the city of Cody has typically used this same statute for any CUP decision, and that had basically been conceded. And so this particular ordinance governed, and that the June 15th meeting, even though it didn't have a full board, it didn't have a majority of the full board of 7 members, it did have a vote of a majority of the 5 members that were in attendance at that meeting. And so for all intents and purposes, the CUP was essentially approved with the conditions that were put on it by the city planner and the staff at the city at that meeting. And the obvious...
So long ago.
Sorry, go ahead.
I have to say, so long ago. Like, I can't even... How many podcasts have we done since then, right? And no one had any idea. So is there any way that anyone can push back on that? The fact that it is not specifically for churches, or it's just common use that
I think that would be a really difficult argument. I also think it'd be a really difficult argument. I'm going to assume that what you've heard, Landon, is correct, and that there is some state statute that may have slightly different terms. It's really tough from the city's perspective to essentially argue we don't have to follow our own code, or like that our own code basically is in violation or is inconsistent with state statute. That's just a real tough argument to make. I mean, technically you can. It's just typically not going to go very far with most courts. I think the other thing is the historic practice of how the city had typically treated CUP decisions also seemed to be a big focus of the court's decision, which really is actually pretty brief. If we looked at it, it's really just, this is really the main issue that the court adjudicated, and everything after that just basically follows logically from that. But you can see it right here. Let me just read this. Okay. Let me read this line, and then you can ask your question. So right after the court quotes from that ordinance, it specifically states, though a house of worship such as the proposed temple here does not fall under the literal definition of a commercial building, the city of Cody has traditionally considered churches and schools as being subject to the approval of the Planning and Zoning Board and City Ordinance 9-2-3. And so while technically, Rebecca, they could try and appeal that specific portion of the decision, it's really tough to basically say, hey, court, we know that we've done things wrong in the past, but we shouldn't have been doing it that way, and you shouldn't have treated the way that we had done it historically as being legitimate. That's one of the reasons that's just kind of a tough argument to make. Yeah.
Again, cautionary tale to town. Shore up your ordinances, right? Get these things right.
But in this case, there was a procedural error in that the board said it didn't pass when it did, and therefore the POCN did not appeal because they thought that it had not passed.
They based their actions on that procedural error. I wonder if there's an argument there.
I've thought the same thing. That's probably closer. That's probably a more successful argument than basically saying, hey, the way we've historically treated this, just ignore that and look the other way. And that's probably one of the things they're looking at is, did the wonkiness of the procedure make things so unclear that it essentially amounted to a due process violation? And I'm not sure whether they already advanced that argument, because I haven't reviewed the arguments from the attorneys aside from what the court recounts here. And he doesn't, the judge in resolving the question doesn't deal with that. But that's probably an argument that I would have advanced. I also would have advanced arguments about the city planner's involvement, and whether that, because the due process clause of the Constitution, so we have two of them. One is in the Fifth Amendment, and one of them is in the 14th Amendment. And the one that's in the 14th Amendment, which was passed after the Civil War and the Reconstruction era, is what applies to state action. The Fifth Amendment one applies to federal government action, okay? And that's one of the arguments I would have advanced, is that due process, it's a hallmark of due process that you are to have a neutral and detached decision maker adjudicating your case or your issue, and that you're to be provided notice and an opportunity to be heard. And I would have advanced arguments about the due process problems with the procedure and the city planner's involvement. I just don't know if that's what the residents group's attorney asserted, or if they advanced those arguments on the July 25th and the August 8th meeting, but not technically on this one. Well, I just don't know enough about
I don't think they could, because they, by the time they got the information that this was happening behind the scenes, all of these dates had already passed. And then when they tried to get it in the record, they said, no, we don't. We, just like you said, we can't look at information like that. So by the time they got the evidence,
also the town was not forthcoming. Like, they had to go back and request and even take it to court. Remember that, Landon?
Yeah. To get all of the documents. So.
Yeah, sorry, go ahead. I just wanted to make that point, that they were not forthcoming. They had to go after him again legally and say, you need to provide these, all this, the text, the emails.
Well, and aside from just not being forthcoming, it seems like even the city didn't have any idea that it had voted on and basically effectually approved the CUP at the June 15th meeting, because they had 3 more meetings after that. Think about all the time and staff time and expense that has all basically been rendered to have been nothing, a nullity that had no legal effect. I'm so sorry. I had something in my mind that triggered off of something you said, Rebecca, but now I don't remember.
You off, Landon. Did you want to finish what you said? I just had to add that about the emails.
No, I think I'd said pretty much, but yeah, you're right. They have 3 additional meetings.
Yeah.
The citizens boards are sitting there thinking, we're working through the process. We were covering all of these issues.
All of it.
The newspaper's covering it. Everyone thinks it's still happening. And the judge effectively said, no, this was over on June 15th. Nothing else matters.
Dial it back a year, over a year. Yep.
I remembered exactly what I was going to say. The way you just said that reminded me. This is one of the reasons that lawyers like myself are perpetually pessimists, is because we have to be hyper aware of even the mistakes that are being made by courts, by agencies, by people that aren't even connected to us. Particularly when I was a prosecutor, one of the things that was difficult is, you're trying a case, you're trying to win for a victim or for the state, but you also have to, at least at some level, protect a defendant's constitutional rights as well. It's one of the things, I guess, that I know that people have a lot of frustration at lawyers. I share a lot of those same frustrations, but to just kind of vindicate my profession for a second, it's one of the reasons that lawyers do have to grapple with such difficult issues, is we have to read the tea leaves and really have done the research and know that this may have been an issue and could have at least potentially attempted to get a petition in there just as even a placeholder to preserve those appellate rights. Because when you fail to comply with a time limit, like a hard jurisdictional time limit like this, you're just completely screwed. There's really nothing you can do about it, except in like the rarest of rare circumstances. And so that was what I wanted to share, is that seeing how easy it can be to just assume that people know how their own process works. This is one of the reasons that lawyers have to like hyper in-depth scrutinize things, is because this is what happens when it doesn't happen, or at least can potentially.
This should be a cautionary tale to any city or any group that is going up against this, because, you know, from the date when they first learned about the temple and what it was going to look like until this time where they had 10 days to appeal was 9 days. This group has no money. They haven't they don't have the resources to hire a lawyer. They don't even know that if they need a lawyer at this point. And so it's almost like the second you see this, you need to grab a lawyer and have them involved right at the first, so you don't miss any procedural. But again, how does a small neighborhood raise the funds to hire a lawyer before they even know what it is that they aren't approving of?
Yeah, absolutely. And that's where we would, as applied to the facts of this situation, it just feels super unfair. But that's where then we would just pivot back to our earlier comments about the way to fix stuff like this is to hold the government, including the local government, more accountable by having timelines in the city ordinances or even in state statute that do require more notice than 9 days for like something
a 60-day review or something would be reasonable. Now you've got a chance to ask some questions, do some digging, decide if how you're gonna prepare for the zoning meeting so that you've got something to say. That just seems, 9 days just does not, and the church counts on that. They try to push this through as quickly as they can because they don't want neighborhood groups to be able to organize to come back at them. And this is absolutely a very difficult when you've got a billion-dollar organization with hundreds of attorneys working for it against a neighborhood group that gets 9 days and has zero legal representation at the time.
Well, and like we just saw I know we saw it in Springfield, Missouri, and another town, I can't remember, where when they approached the P&Z board with the application, the person approaching would not even divulge who they were working for. They would not say the name of the church, even when people on the board say, "Can you tell us who this is?" Because, all they know is it's a religious structure, which 99.9% of people are going to think it's a church, a neighborhood church. That's fine. If they were to hear LDS, some of them might know what could be headed their way, our gargantuan building. Mm-hmm. And so they're taking it a step farther. The location is nebulous. Now, even the person behind the application is nebulous. And with these shortened periods, you can just pounce right in there before neighbors can even try to talk amongst themselves or mobilize or decide what course of action. So it seems very unfair, like you said, but legal, like you said. So I guess the only way to make the change is to try to go at the law in that way, city or state. So that's very interesting.
Yeah, it is. And so essentially the rest of the decision, the court deals with, in the law, we have this term known as ultra vires. Ultra vires just means that it goes beyond your statutory authority. It's some action that you've taken that wasn't authorized. And so here, essentially, when the court finds that the June 15th meeting approved the board's decision there, did approve the church's CUP, anything that comes after that essentially would be ultra vires. It would be beyond the scope of their authority. The court specifically looks at the fact that while the board attempted to put some conditions in these later meetings, and we talked about those a few minutes ago, they only had the authority to do that after they had satisfied certain conditions. And so the court just found that those conditions weren't satisfied, that because, and this really just all touches back on our analysis of the first issue, in the sense that if the P&Z board had known that they needed to comply with those conditions because they had technically approved the church's CUP at that June 15th meeting, they could have gone through those procedural steps to add additional conditions, to reopen the matter, to reconsider the matter, but they didn't take any of those actions. They didn't provide the notice to the church that their ordinances or state law, it looks like it's ordinances, would have required before they take that action. And so the court ultimately found that they hadn't made the required findings, they hadn't provided the required notice. And so those subsequent meetings where the board attempted to modify the CUP were invalid, and so ultimately vindicated the church.
So question, so you're saying there could have been a course of action if the P&Z board back in June had recognized what happened. There could have been a little bit of a course of action there, but just like the residents, they were too late because they didn't understand anything that had happened.
Yeah, and that again goes back to my earlier comments about, lawyers having to be eternal pessimists. Is if you're advising the P&Z board and you think there's some legitimate question on whether it had or hadn't passed, the reality is that, are you both familiar with the thought experiment of Schrodinger's cat, where you've got this deals with Heisenberg's uncertainty principle in quantum physics, right? This is like the basis of weird quantum physics woo-woo, where you've got the cat in the box and the box is rigged with a poison device that triggers us off of quantum decay of a molecule. And so the idea is, it's a thought experiment. It's not real. No one's really putting a cat in a box with a poison capsule. But the idea is that when you're dealing with quantum mechanics, you can either know the position of something, or you can, this is what happens when you get a lawyer talking about quantum physics. The point is that you can only know the position of it when you open the box. And so you only know if the cat has died once you open the box, and that deals with the position of electrons and superpositions and all this weirdness of quantum mechanics. Okay. What I was going to say, maybe you should just edit all of this out. What I was going to say is that sometimes when you're dealing with a difficult legal situation like this, that it's like, are we on this track or this track? We don't know. You almost have to consider yourself as being on both tracks at the same time and saying, we're going to comply with these notice requirements, with these finding requirements to reopen this CUP application, because there's this unresolved question of, has it been approved? Has it not been approved? And that's where I got off of my Schrodinger's.
Wow. No, that makes sense. Better safe than sorry. If you were not clear, just to be sure, we better, like you said, open this, take this path, even though that might not be the case. But if it is the case, exactly this, we're screwed.
Although that sounds counterintuitive. It's like in a football game where the referee throws a flag and calls the wrong team for holding and issues the penalty. You don't go and say, hey, you're wrong. We want to, you take the penalty.
We're going to go this way. Yeah.
and you let the other group yell at the ref and you say, oh, well, that went our way. But in this case, what went your way, they all of a sudden said, no, it didn't go your way, even though you were told it went your way. So it seems counterintuitive. And it seems to me that the board, the POCN, they didn't sue the church, or they didn't file against the church. They filed against the city, saying that the city didn't follow the proper procedures to do this, in which case it sounds like they're right in that the city said that it didn't pass when it in fact did, which then threw them to not do the correct action, which then costs this whole thing. And of course, when you throw behind that the fact that the city planner and one of the board members is, highly invested in the outcome of this happening their way, that makes it even muddier. And this is what seems to be the playbook, is that the church has these members that are on the board, or they're we saw that in 3 of the 5 temples, the members, city planners, and members of the board are all LDS. But not everyone. Like Baker has a city planner, I think. Cody had a city planner. We have board members in these cities, and then of course in Lone Mountain we have the, we've made a donation to the city council people. So you've got these insiders that seem to be working for the church that nobody can, because it's a religious organization. You can't say, well, you're that religion, so you have to recuse yourself. But all of us who've been in this high demand religion know what the expectation of you is when you're working on this, that the church takes priority over any civic or any other responsibility, it really leaves a sour taste in your mouth when you see this process and say, the citizens have no ability to fight this when you have an inside man.
Yeah.
I really think that's the difference in Fairview is you didn't have insiders running trying to manipulate the process or trying to steer the process towards one group or the other.
Yeah. And I think I can completely understand their frustration at this decision that's they very likely have, because it does feel completely unfair that the city doesn't even understand whether it had passed the CUP, and yet the residents group is basically being held to account for them not knowing that it had been approved at the June 15th meeting. It does feel very unfair. Yeah. And how all the insider stuff relates to that is, you have more information on that than I do. I think
and again,
one of the
we
things
can't say for sure. We should say that. I mean, all of this, we read the articles, we talked to the residents. Again, we can't say for sure everything that happened or the impact that it had. We can just kind of put things out there and say, isn't this curious?
I mean, the only thing I will note, so I'll scroll back up for 1 second, and because we talked about how at the June 15th meeting, they approved the site plan that had certain conditions that were added there by city staff. And we know that the city planner was involved in that process based on what he said in that news story that you read.
Mm-hmm.
If we look at the bottom of this paragraph here, the court is talking about these subsequent meetings and the way that they were subsequently attempting, the board, was subsequently attempting to modify the site plan or to deal with the light pollution or to deal with the height issues. But one of the things that you can see is the court writes here, in other words, certain conditions must be satisfied before the board is granted any authority to modify a previously approved CUP. If we go down, it says the initial approval of the CUP, so this would have been at that June 15th meeting, the initial approval of the CUP also imposed no conditions of approval that were to be satisfied to move forward with the construction. So it wasn't only the fact that they voted on the CUP at that June 15th meeting, it was also the very specific CUP application that was in front of them. And it sounds like even the board was very confused about what they were actually voting on. But the court is essentially looking at that and saying, well, what you approved didn't have any conditions, which would be unlike the bell tower in Fairview that you were talking about, because that was approved with conditions that still had to be satisfied before it could move forward. So we don't know who did it, but I'll just say whomever on behalf of the city prepared that or assisted with preparing that CUP application and didn't add any conditions before it needed to actually be built, really made the church's position very easy, it seems like.
Well, my
here's
understanding,
where it gets tricky.
Yeah, my
understanding
is that the church put in a special request
Mm-hmm.
to allow them to, a special exemption to allow for the taller steeple. And then the city planner told them, and so the board knew about this special exemption.
Mm-hmm.
And then the city or the church pulled that special
Right
exemption
before.
right before the board. So the board was thinking that they were
Oh.
voting on it with the special exemption.
Yeah.
And then they were informed after the fact, no, you weren't. You voted on it without the special exemption, and now you can't change it,
And
which
therefore
is
you
what the
passed the
judge is
tower.
saying.
Yeah.
But I think that's why the board was trying to go back and change it, because they were going, wait a minute, that wasn't our intent. Our intent was to only approve the site plan without the steeple, and we kind of got hoodwinked. And I think that's where all of this frustration with the city planner began, is they were saying, hey, someone isn't playing right with us, and there's a lot of confusion here, and there shouldn't be. And I think that's what got this whole thing going where it went.
Yeah, because they
Right,
voted, their vote did not reflect their intention. What they intended to do, they were not able to execute that through their voting. And in fact, I think I remember one person said, can I go back and change? my vote because they were so confused. So what they intended to do, they could not execute through their voting process. And then they tried to correct it this whole time. But again, pulling that exemption or whatever it was, the special, whatever it was with the tower, to me, that's super misleading, and it worked. However it happened, it worked.
Yeah. And this, I guess, goes back. It's interesting talking about this case because it feels like I get to bloviate a little bit about appellate practice and procedure, because one of the things we say all the time when I'm talking to younger attorneys about appellate practice is keep your record clean, make your record, make clear exactly what's happening. And it sounds like, again, however it ultimately got to where it got, that just didn't happen here. Mm-hmm. There were people who were voting on things that affect a lot of people who had no idea what they were voting on. And that seems like a real problem to me. Regardless of the legal result, that just is very, very unfair. And the residents have a right to be frustrated about it. I wanted to highlight just in this next section, the court basically adjudicates the June 27th. I think that should actually say July 27th and August 8th meetings the exact same way, basically saying, hey, there were certain conditions. If you wanted to reopen this, there were certain conditions that your ordinances require you to comply with, and you didn't do that. You can see that right here at the bottom of this section, it says a previously approved site plan may only be modified if the Planning and Zoning Board makes certain findings described in the Cody City Ordinance 1014-1-sub-K. Because the Planning and Zoning Board did not make such findings, again, because they were confused about whether it was still open, whether it had been approved, but because they did not make those findings, the court finds that the board acted without legal authority when it attempted to modify the site plan during the June 27th and August 8th, 2023 meetings.
So all those meetings were basically null and void because they not knew what they were supposed to do back in June 15th, where they could have done something, but they didn't realize they had to. So every meeting after that was just null.
It needs to be pointed out here that these are small towns. The Planning and Zoning Board are not professionals. This isn't what they do full time. They're a voluntary board. They get their information and they follow the lead almost always of the city planner, who is a professional, and the city attorney, who is a professional. Those are the two people who they lean on. And that, from the newspaper articles and other things, is what we were seeing as the board is trying to vote on this, and they felt like they're being misled by their own advisors, and they didn't know who they could trust in this process, because there seemed to be such a desire on behalf of the city planner to make sure this thing got through. And they were seeing that, and they were going, I'm not sure the information we're given is correct. And so they're trying to do, they see this and they're trying to react, but they don't have a professional person there advising them on how they can fix this, or they didn't feel that they did.
Right. And they might have felt threatened. Think about that newspaper article where it said, you better have a very good reason for, not thinking you voted this way. You better be able to defend this in court, right? That's threatening to a volunteer person on a board.
And this goes back to what I said. I was given legal advice in my real job, and our attorney said, you think you're going to go to court and get a just decision, and what you get is just a decision. And this is a perfect example of that. Everything screams, is this fair to this group that they, that they didn't know that it hadn't been approved at the time when they didn't file the thing? No, we just got a decision where the judge said, nope, that one is approved, and everything else is null and void because that was approved, even though you didn't know it was approved. Too bad on you. And so you can have all the evidence, all the proof, all the whatever you want. That doesn't mean it's going to go your way in court. And that's the issue with all of these that you're going to see, is these go and you don't know which way a judge might decide. Doesn't mean it's right. It just means they decided on some issue.
Yeah, and to just bolster exactly what you're saying, because I remember you sharing that last time we talked about Fairview, and you're absolutely right. It's one of the reasons that I encourage, my clients or anyone who's facing a legal scenario, that if it's at all possible, to try and just resolve it amicably and reach some type of settlement. Because, and I'll just give you a perfect example. The first case that I took as a legal practitioner to the Idaho Supreme Court was a very complicated issue of constitutional property tax law. Okay. And so I was arguing on behalf of the state that this one case controlled and that it, vindicated my position. The other side was arguing, using the exact same case that I was, that it vindicated their position. And we had two opposing positions. We go to the Supreme Court. We take like a year to, write. And obviously it's not the only thing I'm doing that year, but we take a year to brief the matter. We go and the matter is argued. And what ends up happening is the court, both sides are relying on this case. And the Idaho Supreme Court threw that case out and said, that case that you're both relying on, that's bad law. We're going to change the standard now. And it just goes to highlight exactly what you're saying. And I'm not saying there was anything untoward with that at all. I'm just saying that's just a consequence of appellate practice. Is sometimes you're relying on cases and they get reversed and they get recognized as, nope, we don't agree with that interpretation of what we thought the Constitution meant anymore. Or we don't agree that particular case was the right articulation of this legal principle. We're going to change it. That happens. And it's exactly what you said, Landon. Sometimes it just is the way it is when we're dealing with the legal field. And I just had two more little parts of the decision that basically follow. For the residents, as we talked about, they had only actually appealed the third and fourth meetings, the ones that occurred in July and August. And because they didn't timely appeal the first meeting where the CUP was actually approved, again, because at the time, it sounds like no one really understood that, they essentially lost their appeal rights. And so the judge doesn't even reach the merits of any of their arguments. He basically finds that because they didn't timely appealing is required for the court to have subject matter jurisdiction, which simply means that the court has the power to hear the case. So I think, while I can completely understand the residents' frustrations at the city, and I can completely understand the residents' frustrations at the result, that simply is the requirement, that if you haven't timely appealed the actual decision, the court literally does not have power to even hear and decide that case. And so I think that's really kind of my closing thought. Is I wanted to come up, when you texted me that the decision had been reached, that you all wanted to talk about it, I was excited to, because I think this case can kind of illustrate a cautionary tale of appellate practice, of administrative law, of why it's so important that people get more civically minded and more civically engaged in understanding how quickly changes at even the local government level can happen that drastically affect their lives with very little input from them. Another thing I wanted to highlight is I, as well as you, I'm going to guess, have been accused of only wanting to make the church look bad. And I know we've talked a lot about the unfairness in the things that may have happened in front of the city as far as with the city planner. And that's all been reported on by the local news. But I wanted to report one where I actually think the church, at least the church's position in court, seemed very well supported. And I have no problem saying that when that is the case. And I can completely understand the residents' frustration at the way the city handled things, and at the situation with the city planner, and perhaps with the church's behavior in getting it to that stage. But once that had happened, it seemed to me like the church's legal argument was the correct one. And so, just because I am tired of people saying I only want to talk about the bad stuff the church does, I wanted to highlight the fact that I actually thought their argument here was the legally correct one, and the judge agreed.
Yeah. No, and I can understand that. And that might explain why those headlines so early on said, we're going to sue you because they recognize, perhaps from their perspective, that they had such a strong case, and the rest of us were just little gnats going, stop it, leave them alone, But of course, we see all this other backstory and all of the other things that, as not a legal person or an attorney, we're like, doesn't that matter? Doesn't that stuff really matter? And you're here to tell us, not so much,
Well, and
whether
if I
you like
can,
it or not, or whether it's fair or not. But there are protections in there for all of us, even though it may not seem fair. It is our legal process.
right. And that was one of the reasons I wanted to start with talking about what an appeal is and what a standard of review is, because while the result might feel unfair in this particular case, and I completely agree with the residents who feel like it is, because they basically relied on the city to at least adequately advise them on whether the application had been approved or not. If we didn't have it work this way, where judges have very specific assignments that they're only to consider, the inverse of that would be that judges are just deciding generally what is fair. And that's just not the system that we have. We tend to have judges making the decisions that have been specifically assigned to them by the state legislatures. And that's the system that we have. And while it's not a perfect system and it has holes, the way that we plug those holes isn't by making judges look bad, which is why I really appreciate the residents group highlighting that they agree with the fact that the court rendered a decision and that they agree with the court's authority. They're just going to look and see if there's more to be done as far as whether the court here committed legal error that would ground an appeal to the next level. And we'll see if they disagree with my assessments.
Yeah, there's a lot of layers to this. What do you think, Landon?
Well, the sad part here for the residents of the city was because the lighting ordinances and some of the other restrictions that the city put on the temple were in the later meetings, and those were thrown out. Those also get thrown out, and therefore the residents are left with nothing. They don't have the lighting ordinance agreements. They don't have any of the other things that were decided in the later meetings. And so it's basically, we've been told the church has already moved everything in and is starting the construction at this point. And
the residents lost power yesterday. They were doing some kind of pipe stuff and their internet went off and on or something like that. So, dealing with construction right there in your neighborhood has started.
So, this was devastating to them, the whole thing, and all over basically a procedural issue that they couldn't have really even foreseen at the time. So
I know. But again, we have to always make this statement. The residents would love to have a temple in Cody, Wyoming. That was never the issue. They were just hoping that it could be somewhere a little more conducive, a little more place it would fit in, right, with the height and the light and everything that the church wanted, which they're now going to get. So again, and the residents were extraordinarily respectful in everything. They didn't know anything about the LDS church when this all started. And, they had LDS neighbors and a lot of stuff happened. And there are a lot of really probably negative or difficult feelings there between everybody now, but hopefully moving forward, they can repair everything. That's all you can hope.
Far be it for me to give the church free advice, but it would probably go a long way to smooth over some of those hard feelings, and especially just the way that this entire situation went down, to basically willfully now comply with some.
I think, can you still hear me?
Okay.
Yeah,
like some lighting or something. Yeah, do something,
Exactly.
do something to show that you want to be a good neighbor. Like they always say, there are many things now that they could do. They could show that in action.
Exactly. Sorry, that's exactly what I was going to say, is they could at the very least willfully comply with the lighting conditions if they wanted to. If they wanted to show that they want to be good neighbors and they want to help the people in that residential zone preserve the neighborhood that they moved there for and presumably bought that property for, that would probably go a long way. We have now exhausted my AirPods.
It's over. That's how they tell you to do it. I was going to say one last thing. Already we know of 2 neighbors that are moving. Several are moving. It just has kind of shredded the feeling of the community there and just everything. That's some collateral damage that we've seen in all the different towns that we work with. And that's the really unfortunate side of it. So for a group that says we just want to be good neighbors, if they really understood what was happening, I'd like to think maybe they would do something differently if they really understood what they were doing through these processes. So anyway, well, thank you for having your earbuds go to the very last minute, right, Kolby? Can you still hear us?
You can.
You can. Any last thoughts on this, Landon? And then I guess we'll just wrap it up. This has been really good. Thank you so much for coming on and explaining this. I actually feel better about it in some weird ways. You know what I mean? Because it is just procedurally kind of out of everybody's hands. And I in a weird way, I feel better. I don't know how to explain it, but I do. I'm still devastated for the residents, and I feel sad for the community and the relationships. And, I just wonder if anyone's going to drive past that temple and have positive thoughts. I don't know, maybe in the future.
Well, I guess if there's anything that this showed is it exposed the playbook that the
Yes,
church uses,
it did.
and hats off to the Cody residents.
Yep.
They were really kind of the first ones that really start this whole
The
process
OG.
with other people. They're not the first temple that's had this issue, but they're the ones who were able to bring it to the forefront, and it's helped other residences who can look at this and see what do we do and how do we do it faster, because that's you have zero time. That's the lesson learned here. If it doesn't fit and you want to protect your neighborhood, you have to hire an attorney and jump on it immediately, or the church is counting on the fact that you cannot do that.
Yeah. And I think we saw that especially in McKinney and also Lone Mountain to an extent, where they were able to mobilize very quickly because they kind of knew what to expect from watching podcasts, reading articles, that were picked up nationally about the playbook and the process, and even talking to some of the residents in the other towns. So, and again, none of these towns are saying, don't build a temple in my town. They're saying, please build it somewhere where it fits in the codes and the ordinances, be community minded, be a good neighbor, be civic minded here. Let's do the right thing so that it is, they keep saying it's a blessing, make it a blessing. There are ways that it can be a blessing and a revered building in every town. And I'll say it again, there are many temples that are in the right place, the right location, and are beautiful. I live by one that I think is in the right location, the right size, and it's a pretty building. So just like you, Kolby, I don't want people to think we're just anti-temple, because that is not true at all. So wouldn't you say, Landon?
That's right. That's right. No,
That's
there's
right.
a place,
That's it.
Time and a place for everything. I think the scriptures say that. But every place isn't the right place for every temple, and people are not being bigoted when they say it doesn't belong here.
Yep. Just about the zoning, as Mayor Lesser in Fairview kept saying over and over and over. What's it about? The zoning. No, really, tell me what it's about. The zoning. Anyway, please comment, everybody. Let us know what you all thought of this episode. Did it help you understand things a little bit more clearly in Cody, and maybe also give some insight into some of the other places like Fairview or Lone Mountain or Bakersfield or Heber that we also cover? Please like and subscribe to Mormonish Podcast. And if you'd like to be made aware of when new episodes come out, you can hit that notification bell. If you would like to help financially support Mormonish Podcast, we have links in the show notes to Donor Box. We're a 501(c), and we absolutely, it means so much to us. We appreciate everybody that does donate to us. We absolutely love you guys for that. Thank you so much. If you would like some kind of Mormonish merch, I'll ask you again, Landon, do you have your mug with you? I don't think you do. I think it's in the dishwasher. He's got that. So we'll have to say, as often as you're on, Kolby, we're going to send you some Mormonish merch, because you need to be able to hold that mug up too. So anyway, links in the show notes. And I will, as a quick housekeeping item, we are airing this it is Wednesday, the 28th of August. And typically we air things on Friday. We're not doing it this Friday. We're doing it Wednesday because this is breaking news. Friday, we consider that part of Labor Day weekend. Nobody wants to watch a podcast on Labor Day. So everybody, please have an amazing Labor Day weekend. And we will catch you again on Tuesday after Labor Day at our normal time at 6 p.m. Mountain Time. So thank you again, Kolby. You're just amazing. What was it that DeVays called you again? You told me something funny about how prolific you were. I just love this.
He joked and called me the most prolific ex-Mormon podcaster without his own podcast, which I'm not sure whether that's a compliment or an insult, but I'll take it.
It's a total compliment, because you're so willing to come on and share your expertise and help everybody understand some of these, issues with a fine point, that we wouldn't necessarily be able to navigate on our own. So, and I feel like someday when you do have your own podcast, you've already got a built-in audience, right? Everybody loves you. So thank you so much for coming on. And thank you, Landon, for co-hosting. And we will catch you guys next time on Mormonish Podcast. Thanks, everybody.
Thanks for joining us for another episode of Mormonish. We really appreciate our listeners and would love to hear from you if you have a story you'd like to share. You can email us at mormonishpodcast@gmail.com. You can also find us on Facebook, Instagram, and on our website, mormonishpodcast.org. And don't forget to look for us on YouTube and like and subscribe. Keep joyful, everybody.